How's it going? Jennifer Diane, Rhombohedral, Gloria Fritz. Can y'all hear me? Just want to make sure. I don't remember testing my mic. Testing. Let's see. Oh, might help if I turn my volume up too. Can y'all hear me? Good morning. Good morning. Can you hear me, Jennifer? You can't hear me, Tina? Testing. Okay, good. Thank you, Rotary Dial. Thank you, Jennifer Diane. How's everybody doing? I had to take my albuterol, so I'm like, it makes me shake. Just kind of rolling through. See what you guys are gossiping about. Tina Reddington, Gloria Fritz, KJ and the Ray, Kathy. Thank you, Kathy. Nettie, Lori Colley, Ashlyn. I wonder, it doesn't look like my daughter's profile picture, but it sure does look like a different name. Maybe not. My daughter's name is Ashlyn. Tylee's middle name was Ashlyn, but with 2 N's. Anyways, who else? I know Breaking Crime with Big E, Too Many Feathers. Anne-Marie Atherton. Lisa Thorne. Hello to everybody. Gloria Fritz, Donna Donald, Heidi's Haunts, Kim Lawrence. I'm hot. Liz Johnson. Okie dokie. I'm trying to get it. Ashley Kane. All right. Let me go back. Get back to Dancing in the Rain. Spread Love Not Hate. PJ. Nana Bean. Nettie. Dahlia Gavon, I think. Well, you're welcome. Everybody's welcome here. Siggy D, that's a different name. All right. Well, since I don't have Big E here, I don't know where he's at. Maybe he'll be here soon. I am going to go ahead and I brought my chair in here and it's turning. And I always sit cross like Indian style. And so my chair will just do this. So yeah. I had to bring this chair in here because it's taller. The other one's not so tall. All right. So I've got to go. I'm going to have to kind of ignore chat. So I can go and look up the court website. I just want to make sure it's up and going. So that's what I'm doing. I'm not being a bitch. Not this time. I hope everybody on the east side of the state is okay. There's a bad tornado that ripped through New Orleans. The sucker was huge. Okay. All right, so I have that. Now let me go ahead and get my share screen going. Hello, April Passy, Jean Panek. All right, let's see, share screen. Okay. Mm-hmm. Woo, 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 woo. I'm doing better. I'm getting better at this. Hey, Carrie Ann. How you doing, hon? Hey, little brands. Blazer, good morning to you too. Good morning to everybody. Southern Oregon. Jeez. I bet it's beautiful there. Hey, insightful one. Let me lower my chair. Oh. Boom, boom. Things start bouncing. Anyways. How you doing, girl?
Oh,
Good. Ah, yay.
Again.
Yeah, let me take this off. I'm sorry. Whoa. How's it going? So glad to see you.
Tracy. How are you doing?
Okay. I know. I look frazzled.
Yeah.
Okay. Just whatever. Just whatever.
Just whatever.
Never know what we're going to get.
Yeah. I mean, I haven't talked to you forever.
I know. But you had a good little, I guess, break, you know.
Yes. Yeah.
A
I had
much
some
needed
fun.
break and deserved.
Yes. I did have some fun. And then I came home and Idaho decided it would actually, I'm pretty sure it was Zulema that sent the windstorm. Because I was driving from
She sends, oh my God, that's hard to say. She sends shitstorms. Rolled through last night.
she like I don't know, like after Boise, as I drove after Boise, I started hitting really bad wind, and then I hit Burley, accidentally missed the exit to get gas, and it went crazy to where I was like fighting to keep the car on the road.
Right.
And I mean, I guess going 85 and 90 isn't like exactly good in a windstorm, but
no, it doesn't make you more aerodynamic.
yeah, as I was on the 84 and I turned onto it, and it was like low visibility, and I was like, okay, all right. It was no visibility. It was like a huge dust storm. I could not even see in front of the car. I turned on my lights. I was like, I really hope as the semi behind me sees me and the semi in front of me has his lights on, because I can't see.
You just tap your brakes, make sure.
Yeah, I was so nervous, and I haven't been nervous like that for a really, really long time. But yeah. I made it, and then I got
white
home.
knuckle.
Yeah. Oh, it was totally like my whole body hurt. I was like,
yeah.
And then I got home, and I was going through some stuff for school, and there were two classes that I thought conflicted, and if they did, it means another year. And I was like, I can't. No.
This isn't multiple probation college.
Yeah, I drank half a bottle of wine.
We didn't go. Yeah. Hey, sweet cherry.
So hi, everyone.
Everyone says having a good morning.
I will be here until about 9:50, 9:55, and then I have a meeting. Then I'll see if I can come back. So
I don't have any. I have no idea how long this is going to last. Never know. There's always extra, and then we sit around and talk.
Yeah.
I'm like, oh my God, cut it off already. And like to myself, like stop talking.
But it's, you have people in the chat and stuff like that, and you like, I find it hard
interacting, right?
Cut it off.
It's hard to have a segue out, you know. You're just kind of like, except for you, you're just like, boom, gone.
I know. Well, I take after my dad in that way. My dad, I joke that I think he might be where my son got his autism from, because he will just leave. So like we'll be having a party and all of a sudden it's like, well, where did dad go? And he's just like, okay. And so I am kind of like him, but I kind of almost have to do it because I'll stay on forever.
Right. Larry, for the longest time, he would say, you'd be on the phone with him, you know, and he would just hang up. And I'd be like, hey, oh, okay. Until I was like, he's being mean. He's mad at me or something. But no, he's now to where he'll do it. And I'm like, no, go back.
Yeah.
Go back to old you.
I'm trying. I'm so dark.
Oh, yeah. Prejudiced. You're dark. Chad's not there. He's not rating you, is he? Right.
Oh,
yeah. There. Boom. Oh, he has no mic.
They probably would think that I was dark. I imagine. So
I'm sure we're all dark. Here. I'm okay. Join the zombie club.
Yeah. Hello, Mr. Big E. Who
he's got his mic muted. Or do I have him? I don't know.
I think he's got it muted.
Oh, I do. I don't know. I never do that.
Oh, can't unmute your guests because they chose to mute themselves. There you go.
Choices.
Hey, I'll be on in just a couple minutes, okay?
We're going to meet you again. No, I'm just kidding.
Okay. I'm working on something real quick.
Okay.
So is this live?
Yeah, it will be in about 16 minutes.
Yeah.
Oh, so, it is hard to type everyone's name, huh? Sweet Sherry. That's how I learned. I was like, how does YouTube work? That's why everybody, I'm telling you, I spent a lot of money in super chats when I first got into this, because I was like, damn it, you didn't see my comment. Oh, I didn't know how to highlight names. I didn't know what any of that stuff was.
Yeah. KJ says it's, oh, that's right, because I put it on my wall. So about a month ago, was it a month ago? You sent me the ad.
Yeah. The Fern Foundation?
Yeah. Because we watch them all the time. We keep track.
I never take my eyes off anybody.
Yeah.
Except for y'all. Oh.
And so it's supposed to be like a prepper /
It's basically the same circuit that we're on, you know. Same.
Jason Mal will be there, and I have some questions. I would like to think that I'm, you know, like a reporter and like
privy.
Yeah, but I'm kind of a coward, like in public.
They're cowards.
But I think what I tend to do, which is like, oh yeah, and then I'll drop the bomb and walk away.
Like your dad.
Yeah. I'll just be like, boom, and then leave him in an awkward position, and like, you know.
That's when you leave you got to plant a microphone.
Yeah. I'll just be like, why did you wipe all your podcasts? That's so weird.
Do you have them available?
Yeah. Did you save them somewhere?
I know you did, because you love to see yourself.
Yeah. Yeah, I think it's definitely.
For the most talkingest group of people, when we approach or whatever, they're like, and they're quiet, pleading the fifth.
Yeah, well, they got to keep that membership.
Yeah, I want to know, like, why? What? I really do. This is a legitimate concern question. I want to know, what does that temple recommend mean to a Latter-day Saint member?
It's very
powerful.
It's a very sacred thing. It's very. I know they say.
No, I'm being serious. I don't expect you to answer it, but I just say it because you go ahead.
If you get your temple recommend pulled, it's very embarrassing.
It's worse than excommunication, I think.
Oh yeah. Oh yeah, but again, you can be rebaptized in a year if you repent. So it's not like
whom?
write you off
God?
completely. Huh?
If you repent to God, or
Yeah, usually what has to happen is there's like, I call it a committee, but it's like the stake president is usually involved, the bishop is usually involved, and they have this like, yeah, I would just say it's a committee. They have a meeting with you. They go over the evidence of why you should be, why your membership should be revoked.
yeah.
And then, I mean, and they can take your temple recommend away without doing that. Like, you can just have your temple recommend
Let me
revoked.
combine that though. So when they let's say they whatever, the equivalent to excommunication. Let's say they do that. Does that revoke your temple recommend?
Yes.
Does they go hand in hand? Can you
Yes.
have one without the other? Just wanted to know. I
Yeah,
forgot to ask.
you can have your temple recommend revoked and still be a member. They can just say, like, we don't like what you're doing.
Yeah.
Stop cheating with the elders quorum.
Yeah.
President. Or they can go ahead and have a full, it's kind of like a hearing, and they record it, and then they like tear up the notes. It's like, it's pretty
well,
formal.
I mean, I understand. What time does the hearing start? Eastern Standard Time, 11:30.
And yes,
I may not be correct.
Yeah, Ashley. Oh, first, who asked? Someone asked if I was going to attend. I'm going to try.
That was San Willow.
In case.
Yeah,
I don't know.
She wasn't able to get into the other one. Remember the one, and it was like the year. I mean, it was the anniversary for JJ's death weekend or something. Like,
yes,
because I never know what day he really died on.
It was in the fall, September.
Yeah, and I was like, "Oh my God, really? Like on a Thursday? Really?" I was
I was gonna go, but I didn't think it was safe because of the situation with the pandemic. So I chickened out of that one. But Ashley King just asked,
yeah, here it is.
Did Adam or Charles say her temple recommend were taken away? So she, I believe, had her temple recommend temporarily revoked because there's a text message between Charles and her where he said, this is why you don't have your temple recommend. But she did get it back because we know that there were temple receipts in November of 2019. Chad and her got into the temple. They did do temple work. So she probably just had it like temporarily revoked. And then she was able to, pull her fembot and they gave it back.
Thank you, April. I'm sorry. I didn't see.
Yeah, that's a good way to explain it.
Yeah. Well, thank you. I mean, I don't know why. I've never really even thought of it. It's like, as you go, you learn. The more you learn, the more you know to ask. The more you ask, the better you feel. And that's why you eat beans every meal. No. That's a stupid thing. I got to be dumb.
I've done that.
Yeah. Let me go check. Let me figure this out.
Yeah, I didn't know if it was live in there because I see it on the dashboard. But I don't know if you have to refresh it.
Yeah.
I can check on
Crusher the refresher.
What's the channel name?
Judge Stephen Boyce.
Okay. I'll just stick it on my.
I'm refreshing. What I'll do, let me go ahead, because since I'm sharing it, so I'll just put us to the side. And I've never been inside the box. Inside the box.
Inside the box?
Outside the box. Inside the box. Okay, I'll stop. Maybe. Anyways, Ashley asked, has Chad ever had his taken away before all of these killings?
The church doesn't announce that. I don't believe so. He was an active member. He had callings.
Yeah.
He
wouldn't a treasurer or something, secretary,
a clerk, a ward clerk.
Might want to check your books.
Now, I have a couple theories, which is what I really think happened, which is just that nobody caught it until after all of this broke.
It's just too far.
And, there wasn't, because I don't know if he has access to like the membership system. And sometimes, well, no, he wouldn't, because he wouldn't have been, never mind, scratch that. So,
Yeah.
I
Good
mean,
morning, Nathan.
Mary McInnes, he has had his membership withdrawn. He, though, like I said, they actually will look at legal. This is why I don't know if, and the church doesn't announce it, so we don't know about Lori unless her family comes out and says it.
Or if there's court papers.
Yeah, but I would imagine that given her mental health status and given that everything's on a stay, that it would be up to her leadership to do that or not, and they may not. They usually like to see the court system see things through. And they, and I did see the letter from Carrie Livingston. Yeah. So definitely, I don't know how Court TV got a hold of that.
I swear, if I had a little money, if I was a betting woman, I definitely would place my bet right now.
I'm sure. Well, I think someone leaked it who had an interest in, because that was a major issue, as people were like, well, did he get it? Like, where is this? So I have a feeling that maybe it was leaked by someone in a leadership position.
Or Eanes
or his family, or maybe his family did.
Yeah.
I don't think Mark Means would have leaked it, because Mark Means wouldn't have access to it because he's not Chad's attorney.
True, huh? True.
Yeah, so I don't think he would have. Now
maybe that got crossed at the copy machine or at the water thing, because they had the same office. I'm joking, but I got to be a smart ass. So it's what I do.
But like I said, you can repent and be rebaptized in a year. So this isn't like
long term.
And honestly, does it matter? Like when it comes,
it doesn't, right?
Does it really matter?
Who, a temple recommend it, and I mean, no disrespect, but to me, I'm not of that religion, so it doesn't. But yet, it doesn't. I don't know. Let me think on that.
Because I don't feel like
there's a good answer, because I don't want to be one-sided. It depends on how. Maybe it would have made a difference had it been caught sooner. I don't know.
Possibly.
That's just those woulda, shoulda, coulda questions. However, also for future prevention, proactive versus reactive.
Ultimately, he used that belief system to justify, in his mind, his actions, and Lori did too. And they knew their scriptures. I mean, I'm sorry, they did. Now, that doesn't mean they interpret them right, because Crush and I, we will look through at these passages and we're like, ooh. Like, there's one, that they quoted in Helaman, and I'm like, that's not what it's fucking about. What the hell? Like, so some of them they'll take very literally, and some they'll take figuratively, and that's what I've noticed throughout.
Cherry picking.
But they did definitely know, these people in like this Book of Mormon evidence or Firm Foundation conference, these people know the doctrine. They know the original
exactly
doctrine.
What we're talking about. They know exactly what this is.
Yeah. But and they use it. They exploited it. They didn't. When people say like or accuse me of going after the church, it's like, you'd have to be an idiot to think the church would sanction something like this. And that's not what I'm saying. I'm saying this is where it came from. And that's all I'm saying. I don't really have a judgment about
me neither. I just
the church one way or another.
The bottom of it. It would have saved time, energy. It would have, answers a lot of questions for sure.
Yeah.
It would have shown respect. It would have shown integrity. It would have shown me so many things, not just me, everybody, for the world to see.
Yeah.
That's what I respect.
My issue is talk about it. You just need to talk about these things. If you don't talk about it, then you have these things happen. So just admit it happened, and then do what you can to encourage your leadership to take these things seriously. Take something, because these people are church.
Pretend like it's your child, your brother, your sister, your mother, whatever. Hey, KJ.
Hey, how's it going? Good morning, everyone.
Hello.
Good morning to you. Hello. Hello, Governor.
Right.
I'm just goofy today. I'm goofy every day.
I think today is going to be very, very enlightening. And if I have any advice at all for all of you out there listening right now, do yourself a favor and take a piece of paper and a pen or a pencil out and write.
Julie Rowe. You can have notes.
Write your notes. It just can be your notes. You know, something you find interesting. I believe there's going to be a lot of reading between the lines. How does a defense attorney say he's got to have reasons for saying why something should be dismissed? So he's got to bring out some of maybe a generalization of what he's talking about in terms of discovery or evidence.
Yeah.
He can't just say. He's got to be specific, right?
Yeah, I mean, I think we'll hear, quite honestly, and
quite frankly,
his BS argument of whatever it is. But honestly, the judge wouldn't sever. To me, when he wouldn't grant that severance, I was like, that's a good sign to me.
Yeah, that's common sense right there, Elmom. Definitely.
He was going to go on that's like the judge going back on something that he granted too.
But we got to also keep this in mind. Even though he has not granted that severance right now, down the road, that option's still available.
Right.
It could still happen. I'm not saying it will. I'm just saying if, say, she ain't there January 2023, then there would be an obvious time that he would have to consider that. But it doesn't matter to me. As long as Chad Daybell's on the chopping block and wanting to take it all the way, I can hold off on Lori. I mean, she ain't going anywhere, and she'll get hers either in Idaho or Arizona.
Yep.
You guys hear the bird?
Oh, yeah.
Okay. All right. Well, we'll be going. Let's take you on a tour.
Wait, I'm not in there. I
can't see. Real quickly, Elmom, when you said you were going to this conference, right? This conference what is the subject matter in this conference?
They really just talk about their theories regarding the Book of Mormon. There's something called the Heartland model. I don't really get it.
And the Heartland, and
I think Jesus was in Missouri.
A lot to do with Rod Meldrum, who, along with Nancy and Mike James, Preparing a People, Sean Littlebear refers to him in his interview with Hidden. There's just they're lumped in there just like a lot of people. It's that circuit, that circle. And
I thought the conferences, after all this crap went down, that all that kind of broke apart. This is still being funded by Nancy and Rick James.
Probably
Rick James. Mike James.
And Book of, they split though.
Book of Mormon, officially, I got an email September 2nd or September 5th. I have it somewhere in my phone, where Rod Meldrum, Book of Mormon evidence, the Firm Foundation, which is him.
Is this a good person or a bad person?
They're not.
I don't know. They're not transparent persons, that's for sure. So
they do a lot of prepping. There's preppers that come in and then they talk about the Constitution and
well, what is it that you're going? Are you going for educational reasons? Or are you going to extract information?
But
I think I'm just really gonna see if I can get in.
Browse.
If I can
safely.
Well, I guarantee you'd get in if Michelle went with you.
Yeah, she is my. I always say like I can't turn on my lights. Thing the room parts like a Red Sea when I shop with her or she's with me because
She
she's
just seems
intimidating
like
looking.
she's a very assertive person that wouldn't put up with nothing. You know, she just,
Yeah,
maybe I'm wrong. She could be a sweet teddy bear.
she is a marshmallow teddy bear. Yeah, I'm actually. I
The
know
main
this is
one,
hard to.
You're
There we
the
go.
you're the
you're the
muscle.
main one.
Yeah.
I don't.
Well, with salespeople, because I was in sales, so I don't. There are certain salespeople that will. I'll kind of be like, no.
Check out Rainy April's comment, and it's true.
Yeah.
Take
And
that down. Thank you. I like the
yeah.
sunlight. Woo! There's some sun. I'm refreshing, guys. I don't understand. I don't know. Maybe they're in a breakout room.
He may not have known them. I don't think we've seen
I
that he knew them personally, right?
I just don't want to. I just wouldn't want to see you go there and
I'll
anybody.
go. I want to go. I just can't.
I just wouldn't want anyone to be disrespectful to you or anything, Mom.
You
Oh,
just be
yeah.
where, you know,
I
be
think
mic'd up. Be cameraed and mic'd up.
You know, this
think I just kinda
is
wanna
supposed to
observe.
be a bunch of people that love others. Like, you know, everybody's supposed to love everybody and everything. And
But they're not very transparent. Again, and that's 2 kids missing. That's dead spouses in the wake. So they're not really. If that don't, you know, call someone to come forward, then I don't really think anything else will.
Yeah, I just
Maybe
wish
their
they
temple
would.
recommends being revoked. That might make them step up.
so
But
are you just going to kind of just research things? Maybe
I'm
I'm
just
just.
I'm really just curious to see how it's changed because they like the conference after this, they were like, no like near death experiences because they had a bunch of people doing that. So
they're
I just
bad.
kind of want to see like the dynamics. I don't think I'll go up to, I mean, I might ask Jason Mal, like, oh, why did you, I miss your podcast. But I totally think that, you know, I'm not one for confrontation in public. I mean, I can talk to my camera and look like I'm like that, but really I'm pretty.
I'm the same way. But
I
unless
you don't strike me as someone as being disingenuous. You just always, you know, what you see is what you get.
right.
Yeah, well, I'm definitely like that. But I like to observe and
Me
just
too.
kind of want to see where the direction is. Are there people that are going to talk about the fact that this happened, or are they going to allude to it?
And I think a real important thing would be to just overall observe the overall demographic of the age groups and all that, just to see who is now.
Analytics. Right.
You know, just to see what, you know, what types of people are they? Older people, younger people, are they?
What are they saying? Right. Yep.
What is
Honestly.
they have all the end of the world people, or Second Coming. They have all those, you know, people. There's this white horse.
Dean Sessions, Sean Little Bear, possibly, and his wife Janelle, who's always present.
Well, let me just say this before this thing starts up. The only
If
thing
it ever starts up.
Well, when this court hearing starts up or whatever, but remember back when they were talking about John Pryor had an issue with not being able to get a hold of the state's evidence of the DNA, and that there wasn't enough to test, and then one of y'all said that that John Pryor could observe, but John Pryor was talking about, you know, he wanted to bring his own tester in and all this and that.
That's fine. That's fine. But with so little evidence, we're sorry that I'm not sorry. No, I'm not sorry that
the only reason I bring
somebody who left, you know, mere pieces to that baby girl. Okay?
Yeah,
so that's not really. I know.
What I'm saying is he's trying to come here today to say he wants the case against him dismissed. And, you know, I'm not saying it could be something he not even brings up. I mean, he might got a flask of 100 proof whiskey in his briefcase. All I'm saying is that, you know, what if he brings up these things about not being able to, because he's got the discovery.
He can. But we just like, okay, look how Lori's already went through. Look, they had Sean Bartholic. That was the first attorney. Then they had Means, Pryor, and Archibald. That's plus the other two that flew in with Mark Means. All these attorneys, they can come in and they can say, well, I want, I deserve, well, I have the right to have somebody sit in and just like there's endless DNA samples. Well, you're going to run out, and so each time you can't just there's very little. So why? I understand one time, like have everybody from each side, or whatever, but not each time, because that's just going to diminish the evidence.
I'm just trying to figure out what his argument's going to be, and it's got to be something relevant. It can't just be, well, Your Honor, this ain't fair.
He's innocent. Okay, all right.
It's got to be something he's going to say. See, this is what I think, and I want y'all to hear me on it. If he says this case has to be dismissed against Chad Daybell, he has to bring up lack of evidence.
Present
And if
from the Fremont County Jail, represented by counsel, Mr. Pryor. State's represented by prosecuting attorney Lindsay Blake. Rob Wood is also attending for prosecution, and Rachel Smith also attending on this remote Zoom hearing. Mr. Archibald, counsel for a co-defendant case. We are conducting this hearing remotely. It's being live streamed on the court's YouTube channel for public access to the hearing. In addition, it's being recorded on the court's Zoom software as well as the FTR system. And there's a record being made by attendance of a court reporter who's making a transcript of the proceedings this morning. The hearing today is on a defendant's motion to dismiss the indictment due to failure to seat an impartial grand jury. I'll note that pleading was filed under seal in the case appropriately as it pertains to information relating to some argument on individual grand jurors whose identifying information is to be kept confidential under the rule. However, this court will conduct the hearing today with an instruction to counsel, which we will do in a separate breakout room on the record, but outside of the court's view or of the public view, to discuss the parameters of what I think should be argued in public or not throughout this hearing. Procedurally, going through how we got here, I'll note there was a motion to dismiss, initially styled as a 12B motion, filed on June 21st of 2021. There was an extension requested for that, which the court granted. That deadline was extended to September of last year, 2021. There was a renewed motion filed September 2nd. There were some objections filed by the state on November 8th to the continuance of the motion. There was a second renewed motion to dismiss filed on December 8th. And then the court issued an order on February 4th stating that there would be this hearing held today on March 23rd. Indicated that a memorandum in support needed to be filed no later than March 9th. Mr. Pryor timely filed his memorandum on March 8th as part of the motion. And at this point, the court has not received any written pleading or objection filed by the state. I would note that during a hearing, I did indicate that I intended to take argument on the motion today to keep the matter moving along. The state had requested this hearing to be continued, and in lieu of continuance, I indicated that I'd be willing to allow argument on the motion today and for supplemental submission of briefing and authority to be submitted at a time to be determined at the conclusion of the hearing by the state. So with that in mind and procedural history, we will go forward on the motion today brought by the defendant to dismiss the indictment. At this time then, I do want to conduct a first, what we'll call a breakout room, which is essentially a sidebar in the virtual world here on Zoom. And in that breakout room, I'm going to discuss with counsel the scope of what I think ought to be referenced in the public purview versus what needs to be kept confidential under the rule for grand juror secrecy. So at this time, Madam Clerk, if you would please arrange for the breakout room, we'll go in there and discuss that issue, then we'll come back and commence with argument on the motion.
And you should all be able to join that room.
Here we go. Here we go. Break out.
So this could he's setting the perimeters on, well, you can't talk about competency.
I'm
You
sorry.
can't talk about grand jury stuff. You can't talk about, he's going to tell them everything that they cannot talk about.
Right.
And then they'll come back and then we'll have to read between the lines.
Right.
Hey, can I say something real quick?
Mm-hmm.
Did you all happen to catch that flash of who else was in this hearing?
Jim?
Archibald,
Mr. Archibald.
great point, Big E.
Yeah, I saw that as they were going out.
So what does that tell us?
Lori is here.
Yep,
I
she's
mean,
listening.
hopefully,
She's listening.
good. I wish she was listening to mine.
What would you say to her, honestly?
Nothing.
That's what I figured. I think you'd probably need time to think about that one.
There's going to be all kinds of these breakout sessions.
I would definitely tell her that it is in fact not worth $1 million. For sure. For sure. Like, she can definitely take that off the table. It's not worth it. Not even 10% of that. Stroop waffles. Y'all are cracking me up over here. Jason.
I know. I wish I could like all these comments. I would love to be able to do that because some of them are so good.
Well, highlight them.
What do you mean? Well, I guess I can put them on the screen.
Hi, everybody in chat. Sorry I'm late. I didn't mean to interrupt y'all's conversation.
Too much pancakes and beer, huh?
Well, I've been doing these corny ass clips before these hearings just so I can say we're going to be on her channel and covering them. And I got a little bit behind with this morning's, and thankfully they were running behind with it. So I still got my clip up, and it's garbage, but I threw it together real quick.
Nothing you do is garbage, Big E.
How are you all doing? You guys having a great morning?
I'm having a really good morning. Knowing that this is going to come and go. And I mean, I'm not one to ruffle any feathers, or maybe I am, but what would happen if Judge did dismiss it? I mean, you talking about America in the throes of anarchy.
Well, does he have the ability to dismiss all charges? Because isn't he charged with like a few things?
If he dismisses the grand jury indictment, yeah, but I mean, it's not.
When the state came out and wanted a continuance on this about John Pryor wanting to dismiss this, in Judge Boyce's decision to deny the state that, he explained he has all the authority. So he has all the authority to do whatever he wants to do. Of course, he's only going to do what he knows can't get him in trouble.
Hello, Trouble. Come on in.
I think I just want to know what they're talking about. I'm sure it's all HIPAA stuff, though.
Yeah, it's probably HIPAA. It's also they can't bring up stuff about the grand jury. That's a secretive thing. Judge Boyce had even said that grand jury before he broke out in these rooms. I mean, I just wish that there was more transparency, but I understand that runs up against procedural law, but
Right.
it's just ridiculous, really.
Wow.
I mean, really, how is it going to hurt anyone to know? And if Archibald is there, that means Lori's watching the proceedings. And with Archibald there, it is relevant that he is there.
Yeah.
I mean, considering that the cases are not severed now.
And considering that they're wanting him, just in my opinion, I feel that they're wanting him there to be a part of this so he can
Defend.
make, yeah, yeah. Because he hasn't been in any other hearing since God knows when. I'd have to go back and look, but I don't.
One where he said
last-
that
It's just strange to me that one of the most important pretrial things, and that was the severance, the motion to sever this case, he wasn't there. And it would seem that if he was really advocating for Lori, he would have been there. It didn't matter that her case is in a stay. He still should have been there, but he wasn't.
Mhm.
Well,
Do y'all think
I don't really know. I don't understand still the whole them arguing that Archibald wasn't allowed to file anything when it's all Mark Means did for 2 years or for over a year during her
when he did?
competency.
Well, is he death penalty?
Yeah,
Yes,
yeah.
he's
I
the
wonder
only
how-
one in on the whole crew that is. There's only like 28 total in the state. 27, 28. And they're like bombed, like there's a lot of caseload on them. I
Yeah.
read into all of that. Yep. So, I mean, I don't know. It's just I was on Crime Talk Live last night, and mom and my dad, my mom and well, my mom was in there, which means my dad's in there. And anyways, I kept asking, but he never did see. There were 1,600 people, so I was like, lottery. And anyways, I just wanted to ask that question about, if Lori is restored to competency, and if she is present, she's not been arraigned yet. When she goes to be arraigned, she cannot waive her right to a speedy trial, thus leaving Chud in the dust, and she would go first. That would be like the ultimate bitch move. But I don't know how that goes. And we sit here and we're like, well, no, yeah, I just kind of want to know strategy. She just seems that way. That's she's extra. So I hear like that Katy Perry song. I got the whatever roar. I can just see Lori.
I could just see Lori at some point she's going to get a plea deal through Archibald. I don't think Lori's going to have a trial, but that's just my theory.
I can see that too. Titanium, yeah. Yeah.
Just as your mom said, Kay, she told Nate Eaton she didn't want to have 2 trials, and
Right.
and how much y'all had suffered and all of that. And I just don't see other than the fact that if she stays incompetent and it runs up against the trial date, then it would be severed then. But in terms of her getting out sooner, in terms of her mental competency and having to go forward, I don't see her rushing to get hers done before Chad. Be honest, I think she wants to sit next to Chad. I think she wants to be at the same trial as Chad.
You can control him there.
I mean,
Can you imagine the minds out? I mean, just the effery going on between all that.
it would just be the best kind of justice object that anybody could want, to have them both at the same hearing. I mean, this whole idea of judicial efficiency and the financial aspect of it, and then to turn around and they end up having two separate deals. I mean,
Right.
they basically been pounding it in our brain all this time, that this is this is judicial efficiency and we're going to have one hearing and all that. But the only thing that I can see is it's going to be a moot point if Lori has a plea deal. And Archibald, he has not done anything meaningful in terms of, remember when, not to give Mark Means any toots or anything, but at least Mark Means was arguing about stuff and filing lots of stuff. Archibald's done nothing. It's like he's just
Maybe Mark did it all.
Well, I think like
been incompetent.
what I wonder is maybe she'll just stay in hospital the rest of her life. There are people that do. And you know what?
Boo, boo.
Either
from the
way.
crowd.
Well, that attorney in Bonneville.
It's not like any of us have a say. We can want it all day long, but we have no say so.
Yeah, that attorney down in Bonneville, who's been an attorney for years and years and years, told Nate Eaton he's only seen one person in 20 years, and it's very, very rare.
Yeah.
But
right.
And he's had all of that other stuff, about her calling Utah and that she's able to watch these hearings and stuff. Why is she able to watch these hearings if she's incompetent? I don't understand that.
Homework.
Yeah, I mean, they do in the hospital, they do have homework. And so when she called, I was like, oh, well, they gave her that homework to see if she can make that call. Now, the thing that I was like, is that she called for spiritual and temporal advice. And temporal is like when you die a temporal death. And so when I heard she talked about temporal advice, I was like, she's still thinking something. And I think she was, and with the spiritual, I think she was probably, hopefully, realizing like, oh, I broke that cardinal
thing.
Becky,
Maggie's back. For y'all read Carrie Ann's comment.
So you believe?
Wait.
Okay.
Sorry.
And I got 2 minutes. Okay, I gotta go. I'll be BRB.
I'll say this, since there's silence right now, I don't think Kay and Larry will allow any deal to be done. They've been staunch death penalty hardcore from the rip. So I don't think.
Here's we're ready to go back on the record here. Is the court reporter ready?
Yes, Judge.
Okay, thank you. All right, Mr. Pryor, as I previously mentioned, then you have filed a motion that was briefed and extensively briefed, and the court appreciates that. That was done on March 8th that you submitted that. So if you'd like to offer argument in support of your motion at this time, you may.
And Judge, I think I had indicated at the last hearing on the 17th that my argument was going to be very brief. I provided a memorandum with the court, a briefing of approximately 55 pages on this issue of the motion to dismiss regarding the grand jury impaneling. There were 2 accompanying briefs that relate to that motion to dismiss that I'd like the court to also consider as they relate to the grand jury proceedings. But Judge, in general, the motion to dismiss is based on the under Rule 6.6 of the Idaho Criminal Rules as it relates to impaneling a fair and impartial grand jury. I have I think in significant detail set forth my reasons for that. I have no intention, obviously, of disclosing the specifics of what I find objectionable. That's laid out in my brief. I'd ask the court to take that into consideration. But Judge, in terms of themes, there's been pervasive media coverage. That plays into the fairness and impartiality of the grand jury proceedings. The prosecuting attorney in this case chose to utilize the grand jury proceeding. I did not choose to do that. They chose to do that. They could have just as easily impaneled a preliminary hearing and chose to go that route. So the decision to use a grand jury was solely on the state. They have an obligation and a duty to impanel a fair and impartial grand jury. It's my position that that was not done. It's my position that the grand jury was, at least in some ways, impartial, or was not partial, was not impartial and was not unbiased. I've laid that out in my brief. The other issue, Judge, is this: is that the potential sentence in this case is death. The severity of this case, and this court addressed that in a prior decision that you set forth, and I believe that was in your memorandum regarding the venue. And you cited that death is different. And the magnitude of the charge, Judge, is what's important here. And when you're considering the validity or the impartiality of a grand jury proceeding, Judge, you have to take into consideration the consequences as a result of that. So there needs to be a higher scrutiny and a higher review of the standards that are set forth. And given that, Judge, I implore the court to look at what I've laid out in my brief and strongly consider that, at least from my perspective, this was not an impartial presentation before this grand jury. I'm asking the court to take, as part of this, the complete record of the grand jury proceedings. I'm asking the court to incorporate my brief and memorandum filed on the 8th and the 2 accompanying briefs as they only relate to the grand jury proceedings, Judge. But I think that if you take the opportunity to review my extensive briefing, I would ask the court to dismiss this indictment on that basis. And thank you, Your Honor. I will now defer to Ms. Blake.
All right, thank you, Mr. Pryor. Ms. Blake, what's the state's response on the motion?
I need to unmute first. Thank you, Your Honor. First of all, the state would indicate, as the court had mentioned at the outset of these proceedings, the state has not had an opportunity to get our brief submitted to the court. At the time that this hearing was set, I believe Mr. Pryor was given approximately 30 days, give or take, to submit a brief. We do recognize that Mr. Pryor absolutely timely filed that brief. He actually filed it a day in advance of the due date. Unfortunately, though, we hadn't looked at the timing of that very closely, and it left the state with only 2 weeks and 1 day from the time we got it to this hearing today. So in order for the state to have actually put a brief together and given Mr. Pryor ample opportunity to review that, that was why the state had originally asked for a continuance. As the court indicated, you had authorized that the parties could seek to supplement any argument with briefing. We would indicate to the court we've been working diligently on a brief, and we would intend to supplement the argument today with that brief. I'm not sure if the court wants to set a timeline on that, when that would be due.
I would like to set a timeline. If you've had a couple of weeks now to work on it, could that be submitted within 2 weeks?
Absolutely, Your Honor. And our hope is that we will actually have it submitted by the beginning of next week, but we will continue to work diligently on getting that put together.
Okay, just to be clear then, let's indicate that your brief will be due no later than Wednesday, April 6th at 5:00 p.m.
And Your Honor, the state does recognize that this is defense's motion. I do not know if Mr. Pryor then wants an opportunity to provide any reply or if he wants to look at it at that time. If he does, I don't know if we also want to set a deadline for any reply brief, whether that be from that April 6th date or just from the filing date that the state actually submits our supplemental briefing.
All right, Mr. Pryor, my inclination on that would be if you want to submit a rebuttal brief to their response, could you have that due a week later on April 13th?
Judge, would it be possible to give me an additional 7 days to the 20th? I anticipate a lengthy response from the state, and I want to make sure. I'm sorry about it.
Okay, we can do that. So April 20th for any rebuttal or responsive brief filed by the defense, 5:00 p.m. will be your deadline for that, Mr. Pryor. Okay, Ms. Blake, then if you want to continue with the substance of your argument.
Thank you, Your Honor. In looking specifically at the grand jury proceedings, there are several rules and statutes in Idaho which are directly applicable and govern those procedures, requirements, duties, and remedies in relation to grand juries. Those are Idaho Criminal Rule 6 through 6.8 and Idaho Code Title 10, Chapters 10 through 16. So in large part, those are what the statutes and rules that the state is going to focus on today. Specifically turning to Idaho Criminal Rule 6.6, that specifically provides the grounds on which a motion to dismiss the indictment may be granted, and it lays out very specific grounds. Again, to not belabor the point, I think only a few of those are what was focused on by the defendant. And actually really the second one, that a valid challenge to an individual juror who served on the grand jury that found the indictment, except that finding of the valid challenge to one or more members of the grand jury is not grounds for dismissal of the indictment if there are 12 or more qualified jurors concurring in the finding of the indictment. Then when we turn to the Idaho Code, looking at the first section, 19-1001, it lays out that the people or person held to answer a charge for a public offense may challenge the panel of a grand jury or an individual juror. Idaho Code 19-1002 outlines the very specific grounds for challenge to a panel. And then when we turn to Idaho Code 19-1003, that's where we get the outline for the grounds that are allowed to challenge an individual juror that served on a grand jury. Again, there are several challenges laid out, and I think the focus of the defense has been on subsection 6 and 7 regarding 6, that he has formed or expressed an unqualified opinion or belief that the defendant is guilty or not guilty of the offense charged, but a hypothetical opinion founded on hearsay or information supposed to be true, unaccompanied with malice or ill will, shall not disqualify a grand juror or be cause of challenge. And then 7, that a state of mind exists on his part in reference to the case or to either party, which satisfies the court that he cannot act impartially and without prejudice to the substantial rights of the party challenging. Idaho Code 19-1601 also lays out the grounds for setting aside an indictment and includes very specific reasons for which a challenge or an indictment could be set aside. And again, not belaboring those, there are 4 different challenges laid out. And looking at number 4, when the defendant has not been held to answer before the finding of the indictment on any ground which would have been ground for challenge, either to the panel or to any individual grand juror. So what we can see is between the criminal rules and the statutes, there is some overlap when we're looking at challenges to an indictment. And one of the common themes that comes up is a challenge to the individual grand juror or the panel of the grand jury. And that's really been the focus at this point in time. on the defense's request to dismiss the indictment. Looking at State v. Edmondson, 113 Idaho 230, specifically provides the grand jury is an accusing body and not a trial court. Its functions are investigative and charging. Goes on to say the purpose of a grand jury proceeding is to determine whether sufficient probable cause exists to bind the defendant over for trial. The determination of guilt or innocence is saved for a later day. As long as the grand jury has received legally sufficient evidence, which in and of itself supports a finding of probable cause. In addition, in Edmondson, the court provided, we note that dismissal is a drastic remedy and should be exercised only in extreme and outrageous situations, and therefore the defendant has a heavy burden. So in these situations with a motion to dismiss or set aside an indictment, the burden is on the defendant, and the courts have found that it absolutely is a heavy burden and that an actual dismissal of an indictment is an extreme remedy. And one of the things that is touched on briefly or is brought up in the by the defendant is an allegation of prosecutorial misconduct. While the state takes the position that there absolutely was no prosecutorial misconduct, and that'll be outlined more clearly in our brief, but if legally sufficient evidence was presented, the indictment must be dismissed if prosecutorial misconduct in submitting illegal evidence was so egregious as to have a prejudicial effect on the proceeding. And that comes from State v. Forbes, and that's an unpublished opinion, 2020 IDA APP Lexus 352 and 2020 WL 5361067, and that is citing to State v. Martinez 125 Idaho 445.
And on that initial first site, what was the name of the party there, or the defendant in that first part of the site?
It is State v. Forbes, Forbes.
Okay, thank you.
And that case specifically cites to Martinez. It also cites to State v. Brandstetter. In State v. Brandstetter, the citation is 127 Idaho 885. And that citation deals with the court accepting that in making a determination, every legitimate inference that may be drawn from the evidence must be drawn in favor of the indictment. Oftentimes what we see with case law is the evidence or any inference is oftentimes drawn in favor of the defendant. However, when dealing with an indictment, Forbes references it, and Brandstetter also sets out that legitimate inference should be drawn in favor of the indictment. The state recognizes that those specific cases we're dealing with, whether or not appropriate evidence was admitted or whether any inadmissible evidence was presented to the grand jury. And what we see repeatedly with courts' analysis regarding that specific issue is so long, even if there is inadmissible evidence submitted, so long as there's enough evidence striking the inadmissible evidence, the indictment will stand. And that case talks specifically about the prosecutorial misconduct as well, that even if it's alleged, it has to be egregious. And not only does it have to be egregious, but the defendant needs to establish that based on that misconduct, he suffered some form of prejudice. And again, that burden remains on the defendant to establish that, not the state to establish it didn't happen. But again, the state's position is there was no prosecutorial misconduct. Then looking at a case from the Ninth Circuit, Silverthorne v. United States, that's 400 F2D 627. It also outlines that the grand jury deliberates and indicts as an accusing body on the standard of reasonable probability that a crime has been committed by some person. It is not a trial body. The quantum of evidence necessary to indict is not as great as that necessary to convict. If a grand jury is prejudiced by outside sources, when in fact there is insufficient evidence to indict, the greatest safeguard to the liberty of the accused is the petit jury and the rules governing its determination of a defendant's guilt or innocence. And if impartiality among the petit jurors is wanting, the cure is reversal by the appellate courts. And I cite to that case because throughout the defendant's brief, initially the Idaho Code and criminal rules that were cited to by the state are cited to by the defendant. However, as the argument continues forward, most of the case law cited deals specifically with impartiality or actual or impartial or implied bias on the part of jurors that were sitting on a petit or a trial jury rather than a grand jury. And I'm unaware of any case law or other statute or rule that would make the same analysis applicable to the grand jury. And what we see in Silverthorne is the distinction between a petit and a grand jury, and that oftentimes the petit jury actually hearing the case is the safeguard and may even be the remedy, even if there is found to be any defect with regard to an indictment or how the indictment came about. Idaho Criminal Rule 6C provides in part that the district judge is the one that is in charge of impaneling a grand jury, and that district judge also has the opportunity to inquire of the prospective grand jurors and to determine whether or not they are qualified to serve. It goes on to lay out that specifically there are two things that the court looks to determine if they're unqualified to sit as a grand jury. And one of those is Idaho Code 19-1003, which again outlines the specific standard applied when looking at whether or not a grand juror was improper to be seated. And again, indicating that is a different standard than what is applied to a grand juror that may not be seated, or that a challenge may be made, or what challenges may be made if they are sat on a trial jury or a petit jury. And those are Idaho Code 19-2020. They do allow for different challenges jurors, again, focusing back on the heightened burden that a jury trial is actually tasked with. And Idaho Criminal Rule 6.1b is that's the rule that provides in part that the prosecuting attorney has the power and duty to also investigate and inquire whether or not there are grounds for disqualification of any grand juror, and advise the presiding juror of the possible disqualification of a juror. So the voir dire process through grand jury proceedings is very different than through the trial proceedings. There actually is no inherent right under the Idaho criminal rules that the prosecuting attorney even has the opportunity to conduct voir dire. In this situation, the prosecuting attorney did have that opportunity, but it is not specifically the prosecuting attorney has the right or the duty at the commencement of the presentation of an investigation. And that's in large part because a grand jury may sit and hear multiple cases, and each case may be different. A grand juror may have a disqualification for one case that may be presented to them or for certain evidence, but be able to sit for other cases and other evidence.
All right, Ms. Blay, and I think that's kind of an important point to consider. So you're indicating that because clearly in a trial with petit jurors, you've got a vetting of those jurors through the voir dire process conducted by both sides. In a grand jury proceeding, obviously the defense is not present, and there still needs to be some sort of gatekeeper function to make sure you have fair and unbiased jurors that sit as grand jurors. And so you're saying that under Idaho Code 19-1003, there's a different standard applied to challenging grand jurors, or we wouldn't call it voir dire because it's not really that, but to essentially vetting out those jurors that may not be qualified?
Yes, Your Honor. When you look at those specific rules, they actually outline different reasons for which a challenge can be made to a juror. So 19-1003 has 7 possible challenges that are outlined, which can be brought to a challenge an individual juror. Specifically, there is some reference in the defendant's brief to the grounds for challenge under 19-2020, which actually lay out the challenges for a petit or a trial jury, where the challenges allowed are different. And from what the state can discern from looking through case law, it appears that a large part of that differentiation is that the grand jurors, again, are just an investigative body and they're only making a probable cause determination. They're not making a finding of guilt beyond a reasonable doubt. They're not stuck with that paramount decision that is made by an actual petit or trial jury. We can find no case law to support that the same standards would be applicable to the seating of a grand jury. And I think the statutes actually tend to clear up that issue because they are separated out and those challenges are different.
Okay, I appreciate the response. And so to summarize, you'd say essentially it's a lower standard for seating a petit juror versus a trial juror?
Yes, when you look at what the challenges are laid out, it does appear to be that there is a lesser standard because there are other remedies available short of just dismissal or setting aside a verdict if that's where it ended up with a petit jury or a trial jury. Whereas with the grand jury, there are some other remedies available. And again, one of the remedies highlighted in several cases is the ultimate remedy to cure a defect if the court, unless the court determines an additional remedy is necessary, would be to actually have all of the evidence heard before a petit jury that is impartial and making that final determination.
Okay, thanks for those responses. You can continue.
Thank you. And again, the state doesn't want to get too much into some of the specifics, recognizing that the grand jury is a sealed proceeding, but I would mention that from the state's review of things, and again, this will be discussed more in depth in our brief, but from a review of the transcript from the grand jury proceedings, the state's view on that is the court did repeatedly ask follow-up questions, at times to group and at times to individuals who raised their hands in response to a question. And oftentimes those questions dealt with the juror's ability to remain open-minded, fair, and impartial. The state did the same, because again, while the state can't find a rule on point, absolutely giving the state the opportunity to conduct voir dire, we were allowed to conduct it in regard to seating the grand jury. So it is the state's position that both the district court and the state did conduct proper voir dire and did follow up where necessary to ensure that an impartial and unbiased grand jury was in fact seated. Also, and in State v. Dunlap, the court dealt specifically with voir dire in capital cases, and State v. Dunlap is 155 Idaho 345. And it states, while there is no absolute constitutional right to individual voir dire in capital cases, the method of voir dire must comport with due process requirements. So again, that case is actually dealing with the seating of a petit jury versus a grand jury, but it indicates that there is actually no heightened right in a capital case over another case, but that it simply should comport with the due process requirements as any other criminal case should. I think there is some argument, and again, the state will be brief on this because I think it goes into some of the grand jury proceedings, but there is an argument raised regarding the potential of jurors having a relationship with a party or a witness. And the case on point is that the state has found would be State v. Buhanda Velazquez, and that is 129 Idaho 726. And in that case, they did specifically analyze relationships between grand jurors and the prosecuting attorney and whether or not there actually existed a relationship. And that case also cites to a couple other cases where the same analysis was conducted to determine whether or not a relationship between a juror and an attorney would be a basis for disqualification. In State v. Cipher, 92 Idaho 159, the court upheld the trial court's denial of a challenge for cause of a prospective juror who was, at the time of trial, employed by the prosecuting attorney's firm as a janitor. The court held an accused or the person allegedly injured by the offense charged. And then also State v. Major 105 Idaho 4, the court cited to Cipher and held that a relationship between a prospective juror who was a county treasurer and the prosecuting attorney was not that of attorney-client and thus did not suffice to disqualify the juror. And then in State v. Buhanda Velazquez, the court determined as well that there was no impropriety in a juror being sat where the defense alleged that that juror had failed to disclose during voir dire a close and/or business relationship with two prosecutors, one who presented to the grand jury and one who just worked in the office. They ultimately, the Idaho Supreme Court ultimately determined that the proper standard was applied in denying the motion to dismiss because there was no actual evidence to support a relationship between the defendant, with the defendant or the prosecuting attorney, and that it was not such that would have affected that juror's ability to be seated. Again, there are specifics that the state will simply provide in their brief. There are several arguments made by the defendant with regard to individual jurors, and the state believes that all of those jurors were appropriately seated and that they wouldn't need to have been removed. And again, when we look back at the rule, even if the court did find any merit in any of the defendant's arguments, so long as there remain 12 jurors that return a unanimous indictment, the indictment would stand. And again, I just highlight that throughout the briefing, Idaho Code 19-2020 is referenced when arguing challenges to specific grand jurors. But again, the applicable section is Idaho Code 19-1003. However, I would indicate the state's position is even if Idaho Code 19-2020 were applicable to grand jury proceedings, it is the state's position that the grand jurors are still proper and qualified and grand jurors. And again, that will be briefed, more fully briefed. And sorry, Judge, I'm just going over some stuff that I do not think would be appropriate to put on the public record at this time. One of the other arguments raised is that there is an incomplete record of the grand jury proceedings. Idaho Criminal Rule 6.2a provides all proceedings of the grand jury except deliberations must be recorded either stenographically or electronically. The defendant alleges the recordings were stopped at times. And the state would indicate that we believe the proceedings were properly recorded, that there is no rule or statute, again, that the state can locate, which would indicate that a recording should continue to be played if the prosecutors are conducting any kind of sidebar amongst themselves and or if the parties are entering into a break. The defendant cites to Dustin v. Superior Court, which citation is 99 Cal APP 4th 1311 as a grounds to have an indictment dismissed based on the recording not being complete. The state would specifically distinguish that case from the case in front of this court. In Dustin v. Superior Court, the real concern was the prosecuting attorney had actually requested or instructed, the court reporter to leave during both the prosecutor's opening and closing statements to the grand jury. The court in that case essentially determined it would be difficult to imagine an innocent reason for the court reporter to be instructed to leave during the prosecutor's comments, except for that the prosecutor didn't want those to be reviewed later. And even in that situation, and that case also was a little different in the sense that they were looking specifically to the fact that it was a capital case. And so capital cases should be conducted on the record. California did not have a specific rule with regard to the recording of the grand jury proceedings. Idaho does require those proceedings be recorded. The state also recognizes the law regarding capital cases. And it is the state's position that those were properly recorded. The defendant has had an opportunity to look over those transcripts and has clearly raised some allegations based on his review of that transcript. And then looking at Idaho Code 19-1605, it provides that even if an indictment is set aside under these grounds, specifically referring to the above statutes, so with the challenges to the empanelment or the individual grand jurors or the other grounds which would allow for review of an indictment and for it to be set aside, it is not a bar to a future prosecution. In addition, when we look at Idaho Criminal Rule 48, which deals with dismissals, it indicates that a court may, on notice to all parties, dismiss the criminal action on its own motion or a motion of either party, and it provides the grounds, and that includes for any other reason if the court concludes that dismissal will serve the ends of justice. But an order for dismissal is not a bar to a subsequent prosecution for the same felony offense. It would bar a prosecution for the same offense if it were a misdemeanor, but not if it is a felony. And then in a federal district court, specifically the court for the District of the Virgin Islands, in a recent decision, U.S. v. Benjamin, 2019 U.S. DIST, so DIST, Lexus 173202, and 2019 WL 4920875, also looked at the remedies and provide consistent with the impracticality of other remedies concept embodied in both structural and harmless error analysis. The Supreme Court has recognized that defects in criminal proceedings, including those implicating constitutional rights, do not necessarily warrant the ultimate remedy of dismissal of an indictment, let alone dismissal with prejudice, where remedies short of dismissal are available. And that case cites to United States v. Morrison and adopts their language. So again, just in conclusion, it is the state's position that there are no grounds that have been established by the defendant which would support the finding that the indictment needs to be set aside. And that even if the court were to find any grounds to set aside the indictment, complete dismissal and or precluding the state from proceeding forward with another indictment would not be supported by the findings of other cases that have reviewed situations of this nature. And then again, that the defendant does in fact have the burden, and that burden should be established under the appropriate standards set forth by the Idaho legislature and in the Idaho criminal rules. And the state has outlined those today. They will be, again, more fully outlined in our brief. And we would reiterate our request to just submit that supplemental briefing. The state has already granted that, but we will get that submitted as soon as we can. so that the court has that for review. Lastly, I do want to touch on this actually, reiterating.
I do have a follow-up question on the issue you've argued on the sufficiency of the record. And it's a pretty specific question. There's a part of Mr. Pryor's briefing where, and I'll just reference you to that, and it's on page 10, where he indicates that the defense should be entitled to not just the roll of juror numbers on the voting roll, jurors identified only by number, but that those particular jurors and their votes should be identified by name also. Does the state believe that is part of the record that the defense is entitled to in the jury voting rolls?
Your Honor, I think my recollection is what the rule outlines, and I believe I don't have it right in front of me, but I believe it's outlined in the Idaho criminal rules that provides that a defendant can have an opportunity to review the voting sheets. In addition, there's a rule that outlines that at the conclusion of any grand jury proceedings, prior to an indictment either being found or not found, that the voting list should be placed into a sealed envelope. At the outset, grand jurors are assigned specific numbers, and so the voting sheet, it's my understanding, contains those individual numbers. Those numbers are assigned to a specific grand juror. I do believe the defense, I will say it this way, actually, I'm unaware of anything that would specifically allow or specifically prohibit the defense from obtaining the names associated with those juror numbers. Because the state would have had the benefit of knowing which juror number was assigned to which juror, it would follow practical reasoning to the state that the defense could make that request and would be authorized and allowed to review that information as part of the entirety of the record. So the state does recognize the voting sheet would not have contained that, but I'm unaware of anything that prohibits the defense from asking for that or that would prohibit the court from granting it. And again, because the state has that knowledge, it would seem that the defendant should be allowed to review that information as well.
Okay, well, I appreciate the response on that issue.
And then the last point I just wanted to touch on again was looking at that Idaho Code 1003 with regard to a challenge to an individual juror. I would just reiterate specifically that a hypothetical opinion founded on hearsay or information supposed to be true, unaccompanied with malice or ill will, shall not disqualify a grand juror. I think there were some challenges raised based on pretrial publicity. Mr. Pryor touched on that briefly today, and I know it was covered more in depth in his brief, but I think without more of a showing than simply a statement that there was pretrial publicity, and because a juror had viewed that must affect their ability to sit as an impartial juror, is clearly, I think that situation was somewhat anticipated by the writing of that rule. Not this specific situation, but that a situation would arise in which a juror would have heard some outside information or seen some kind of news coverage, but so long as they can set that aside, and I think that is covered. So I would just reiterate that, because I think that was one of the other main points raised by the defense in their brief. Again, we'll more fully brief this, especially where we can get a little more into the specifics of this without violating any kind of grand jury process. We'll cover that more specifically in our brief.
All right, thank you, Ms. Blake. So does that conclude the state's argument, Ms. Blake?
That does, Your Honor, unless the court has any additional questions.
Okay, thank you. Mr. Pryor, would you like to offer a rebuttal argument?
Very briefly, Judge. I noted, Judge, that at least a significant portion of Ms. Blake's argument centered around the evidence that was presented to the grand jury. If the court looks at my brief, the vast majority of my argument, Judge, is the fairness and impartiality of the grand jury itself. And I'm going to rest on the evidence, and the evidence is the wrong word, Judge. I'm going to rest on the contents of my brief in terms of what I presented to the court and the attached references to the transcript itself. I do want to touch on something, Judge, in terms of the incomplete record. Ms. Blake and Mr. Wood and Ms. Smith do not get to decide what portion of the grand jury proceedings I get and what portion I have to specifically request. That's not the way the rule works, and it's somewhat concerning to me that Ms. Blake would suggest to the court that Mr. Pryor at any time could make a request for additional information. That's not the way it works, Judge. Mr. Daybell is entitled to the complete record of the grand jury proceedings. Now, I brought that issue up, and I've referenced where I feel that there has not been a complete record provided to me. And I brought up a couple of instances where that, I believe, at least strongly believe, that's the case. But again, Judge, I'm entitled to that information, and it's not a matter of me requesting additional information or requesting supplement or just requesting information that this prosecutor has access to. If the suggestion from Ms. Blake is that, Judge, if I want to challenge any specific juror for cause, you'll need to request that information to find out who they are so that you'll have an opportunity to do that. That's not the way it works, Judge. That's absolutely contradictory to what the rule is set out and the way this thing is supposed to work.
Which rule specifically are you referring to, Mr. Pryor?
Well, Judge, Rule 6.6 of the Idaho Criminal Rules allows me to challenge any juror for cause. And I'm allowed to do that. And I assume that it would be presumed, Judge, that in order to challenge a specific jury for cause, I should be able to know who they are. I should be able to know what their name is. I should be able to know some information. Now, I did in detail in this brief point out issues that I have with specific jurors. And again, I'm not going to go into that. But the fact is that in order to adequately do that, I would assume that it'd be presumed that I'm allowed to have that information beforehand, and that it's not something that I have to continue to request. And I draw a parallel between this, Judge. The state is under an obligation to provide me all the discovery, and there'll be some subsequent motions addressing that. But they're under an obligation to provide me the information. I would assume, Judge, they're under the same obligation, at least to make sure that I have a complete record of the grand jury proceedings. And Judge, I don't want to belabor this, but I think I laid it out in my brief, and I'll ask the court to examine that. But the vast majority of the cases that Ms. Blake referenced, Judge, simply addressed sufficiency of evidence. They did not suggest that in no way I could challenge the sufficiency and the qualifications of the grand jury. And Judge, I'm going to rest on my brief. I think it was sufficient for the court to see that, at least from my perspective and Mr. Daybell's perspective, the grand jury that was impaneled was not fair. They were not impartial. And I'd ask the court to strike the grand jury proceedings and dismiss this action, Your Honor.
All right, thanks for go ahead, Ms. Blake.
Sorry, if I can just clarify, because it was a question raised by the court. I did find the rule. It's Idaho Criminal Rule 6.5 that addresses getting access to the voting sheets. And what I want to clarify is the state would have no problem providing the names that would associate with the numbers. I believe we still have a record of that. The court would have a record of that as well. The problem is, and why that is not provided, is the grand jury proceedings are secret, and there are many rules governing those, and the state is not allowed to provide information regarding those. So the only reason that the state had referenced that a request may be made to the court is either way, whether the court provides that information or whether it comes from the state. It's the state's understanding in looking at the rules governing grand jury proceedings that we can't disclose information without order of the court. I understand Mr. Pryor's point, it's well taken, but I just wanted to clarify this is not a situation where the state is trying to withhold that information by any means, but it would be information that would either need to be provided by the court or that the state would need to be authorized to provide from the state's interpretation of those rules and statutes.
Okay, I appreciate that final clarification. Counsel, I'll consider this matter submitted as to oral argument on that final remaining issue where there's still a follow-up supplemental brief provided for the defense. I am going to order at this hearing that based on Idaho Criminal Rule 6.5 and a request made by the defense that there's an authorization for the voting rolls to be revealed in terms of identifying jurors by name and not only by juror number. So that information will need to be provided, and I'll authorize that. If you would submit an order to that effect, Mr. Pryor, I'll get that signed so that the administrators of the case in Fremont County and the clerks are able to supply that information, which I presume is held there at the courthouse. That'll be the only ruling I'll make on the issue for today. I will indicate that on the supplemental briefing that's being submitted by both sides, given the nature of the secrecy of grand jury proceedings and for the reasons already determined, allowing for the filing of the first brief under seal, I will order that those supplemental briefs also be filed under seal. And if you could each with your brief just submit an appropriate order also indicating that the matter needs to be sealed and citing the information as being secret under the criminal rules as it relates to grand juries, then we will file those under seal, and that will take care of that administrative process as well. So I'll wait to see the remaining briefs and take the matter under advisement. The court will then issue a written decision after it's been fully submitted. Mr. Pryor, anything further on your motion this morning?
Nothing further, Judge. May we have permission to be excused?
Yes, thank you, Mr. Pryor. Ms. Blake, anything further from the state?
Nothing further at this time, Your Honor. Thank you.
All right, counsel, thanks for your preparation this morning and your arguments, and we will be in recess.
Hey there, fuckface. What'd I miss?
Well, it seems that John Pryor wants to attack the grand jury indictment on Chad Daybell. Can you hear me?
Yeah, I'm just thinking about how much I do not like John Pryor.
Well, I mean, it makes all the sense in the world when we hear that he wants the case against Chad Daybell dismissed. He has to go after the grand jury. And that's what he's going to do. They're going to give him a copy of all their names. He's going to go through all that. He'll figure out how he wants to do that, whether he he's going to excuse my French, but he's going to shit all over the grand jury indictment. That's what you got to have. You got to have either an indictment from a grand jury or a preliminary hearing, and the state chose this time to do a grand jury. So
someone mentioned bias, and that's what I'm worried about.
well, I mean, who's the one that picked the grand jurors to sit on the grand jury?
Yeah.
Because John Pryor wasn't there.
Yeah. Hmm.
Then if you really spill it over into the other thing, and that is who were the witnesses at the grand jury? You had Ian, Melanie P., you had Zulema, you had Heather Daybell, you had all these cast of characters that testified at that grand jury.
Was there a church? I don't remember. Was there a church leader on there? Does anybody know?
In the hearing?
As a witness.
Oh, I'm sure there was.
Yeah.
I mean, it's kind of no way of getting around that. I mean, and that's the thing, like she said, he seems to be, like Pop said, he's going after one particular juror that was seated.
Well,
And
I see that Tina Reddington says, I thought that was the judge who chose the grand juries.
So where was the grand jury from?
in Fremont County.
Shit.
So the
As
word
far as,
comes up.
didn't Lindsay say that, doesn't the prosecution pick the jurors through the voir dire selection? Or did I not hear that right?
Should I Google it?
Well, I know that what happens is they send out all mailings, and they put the grand jury together, just randomly pick so many people, and then they show up, and then they whittle.
Right. They send 1,000 subpoenas out. They send 1,000 out, and then, for whatever reason, they expect 500 of them automatically are going to not be able to do it for job reasons, blah, blah, blah. Then they just whittle it down to where
Yeah.
they send it.
It does look like, according to findlaw.com, that the prosecutor works with the grand jury to decide whether to bring criminal charges or an indictment.
That's what
Usually,
I thought.
16 to 23 people.
And you got just so everybody can have a laugh if you think it's funny, but I know I did. You got to remember, Chad Daybell got a subpoena while he was in jail for jury duty.
Jesus Christ.
I still chuckle at that every time I think about it.
I'm glad, sweet Sherry, you have faith. I am an eternal pessimist. DJ Norman said the magic word, the magic names.
Can y'all hear me?
Yep.
You can? Okay.
Yeah. I mean, I don't know, the magic names, but I mean, it's easy. It's obvious that, there's probably the whole damn jury was a church member. I mean,
In that county.
yeah, I mean, that's what I'm saying. So, he can say it's impartial, but I was just talking about like what Pop said. Is that the witness list?
Yeah, I just can't make it big.
Could they, wouldn't they just dismiss that member of the grand jury and hold another one? Like, they're not just going to be like, okay, well, never mind.
I don't think that they're going to do. I mean, I think this is just something he's going to try. But for my notes here, it says dismissing the indictment. When you do that, evidence that gives probable cause to dismiss an indictment, there is a heavy burden on the defendant to prove any of this. And this whole idea of John Pryor throwing in their prosecutorial misconduct on Rob Wood and them, it's almost saying to me that they did some kind of prosecutorial misconduct when they put this grand jury together, because in the impaneling aspect of it, the proceedings, and John Pryor is stating that that he does not believe there is a fair impartiality And he cites also because of the media coverage, which I don't know where that fits in. But the state responds to it and says the judge has given the state till April 6th by 5 p.m. to turn in their state brief because he gave them time to supplement whatever they've talked about today. And April 20th, he's given John Pryor the rebuttal responsive brief. So that's two more things that they're going to be discussing in terms of the grand jury. No one thought that, I mean, shoot, I was leaning toward thinking that he was going to bring up something about the evidence or something or anything. I had no idea that he was going to go and try to mess with the grand jury. And this is important because it's through this grand jury that you got those indictments.
Yeah, I mean, the Lafferty case, and this is something that's always concerned me, is that one of the jurors in the Lafferty case admitted that he had been pressured by his bishop to render a guilty verdict. And that is the worry that I have with both of these. That's why I was like, don't hold it there. Like,
you think of all the people we don't know about that are all on the sidelines being quiet, but they're cheering Chad and Lori on. I mean, you never know who's going to get on a jury or a grand jury.
Yeah, I will beat the hell out of him.
Right.
I mean, allegedly and figuratively, not literally, but
we don't know the decisions that are being made today, but we do know about the grand jury and that John Pryor does not feel like it's fair and impartial.
And you know, John Pryor, we may not like him, but you know, we got to give him his credit where he's doing his job.
I'm not giving him credit, but he's doing his job.
yeah. And I know a couple people said it was the case jury. I'm just bringing it up as an example that he could possibly use because.
And I just got a text message. I just got a text message that if for some crazy reason it does get dismissed, the second grand jury would be convened to reindict them.
Could
That's from somebody,
not do it in Fremont County.
That's from way above my pay grade. So
or Eastern Idaho in general. Let's like not even include that.
I'm assuming it will be in Fremont.
Like 92% Mormon. Like,
you mean they couldn't move a redo on a grand jury? They couldn't move it over there to Boise since it's the trial.
Yeah, I mean Boise would be better, or another state. Let's get it out of the Mormidor. Let's just move it out of the Mormidor.
I give up.
But I do think, like, I don't think that it will ruin everything. It's just a matter of will it unnecessarily delay stuff or complicate stuff. Like, I'm just worried. It's like, I know that he's not going anywhere.
Well, we're talking about
and let me say that we're not. Or I'm not trying to piss on anybody's. Listen, guys, this isn't getting dismissed. Pryor is simply doing his job.
Mm-hmm.
And Lindsay argued everything that Pryor listed in his brief. She argued everything that he had listed in it. And the biggie was he is specifically pointing a finger at one specific juror. But she even gave all that case law, which I'll be honest, when it comes to reading case law, I fall asleep. But she had all the case law right there saying why it doesn't matter. So I'm meant to be John Pryor and be brief, but it's not getting dismissed. Okay.
Yeah.
Let's just make sure everybody. I hear you. I see your moves. Your lips moving, Crusher, but I don't hear you. I see you. Jenny, use that lip reading skill.
Hey,
Oh, I
Hey,
know. I
there
was
you are.
going to look and see. Someone said that there's only 15% of Mormons in Boise, but the church has stats on that. That doesn't necessarily mean they're active Mormons, but I remember looking at stats on like the church website somewhere, and I thought it was higher, but I do think it's less. So
and then again, does the religion he threw in the spotlight like him or not? You know,
I think they'd want to do anything possible to distance themselves.
right? So it's
So I
like
think the bias would be against.
Chatty Daddy
Yeah.
and the Chinians.
Michelle calls him No Chin Chad.
Yeah, he looks like a thumb. He just sits there like a sore thumb.
Yeah.
I'm
And
No
yeah,
expression, nothing. There, no life.
I'm stuck on this prosecutorial misconduct. I mean, what the hell kind of? I mean, what is the prosecutorial misconduct? What are we talking about here?
I think they're
You
just
give
trying
me-
to say because Rob's Mormon. I think that's really the only thing that they can.
Chad's Mormon.
Yeah, that they can say. Well,
Lori's Mormon.
that the prosecutor is
Charles, Tylee, JJ, Tammy.
Yeah.
You don't discriminate against people and their religious beliefs.
No, it's absolutely BS.
But let's be honest, you know.
Are you talking about the specific tag motions that he had in there about removing Rob and Rachel, or which one are you talking about?
I'm talking about prosecutorial misconduct on Rob Wood, having him taken off the case. And it's my understanding that Rachel Smith, John Pryor wanted some background information from her, which equals to me that whatever background information he wants from her, he wants to use to get her knocked off too.
Okay, but here's the thing. In the last hearing, John Pryor said he will not be arguing those.
Then why was it brought up today about prosecutorial misconduct today?
That has to do with the grand jury, but it doesn't have anything to do with removing any prosecutors from this case.
Well, if you've got prosecutorial misconduct, what happens to somebody if they're found to have prosecutorial misconduct?
I think they would just replace the prosecutor.
That's what I'm trying to say.
Would it be from the same county though? Because I think isn't that an elected position?
All I know is they need to just grab Juan Martinez out of Arizona and bring him on down.
I will say this. I don't know if unhappy is the right word, but I am not thrilled with how Lindsay Blake argues. I haven't been thrilled how Rob Wood argues, and Rachel has been very limited in saying anything except
She's
for
there to do all the footwork. She's the one doing all the
She's the Alex
research.
Cox. Just saying. She's the Alex Cox.
All I know is they need someone who is tough and charismatic, and Rob Wood and Lindsay Blake are neither.
Thank you. I guess that's why
You're
they're
right
not
on spot. You're right on spot. I mean,
I want somebody who's going to get back in their face.
yeah.
Right.
I want to judge.
A John Pryor.
When Pryor says, "May I be dismissed?" I want to judge and say, "Sit your ass down." I'll tell you when you can leave, clown.
Yeah.
Sit the hell down.
Right. Now sit and you stay here. 30
You
30
say
more
quite
minutes.
honestly.
Write it 500 times. I'm sorry, 144,000 times on the board.
But listening and watching Lindsay today, and you had all that dead air
Yeah,
her looking for stuff. I mean,
I get it, but
God,
then
come prepared. Everybody, state, defense,
she
judge,
also,
recorders,
Well,
come
we don't know
prepared.
what they talked about in their breakout room too.
she also does not sit there and fill it with, quite honestly, and frankly, and with all the So
That
I
could be a
appreciate
tactic.
that. She is pretty precise, and
It could be a
I mean,
tactic.
she's, huh?
It could be a tactic.
True.
Sorry, I interrupted you.
No, it's easy to do here. I don't know. I don't know. They may win some battles, but they're not going to win the war. That is
No.
bottom line. No, that doesn't happen in this story. Not in this one. I've said that. I felt that from the beginning. I've said it from the beginning. My parents have felt and said that from the beginning. No, we just have to trust in the judicial system, which we have in place for a reason. I know, speaking from my perspective, is just that we want to navigate it. We want to drive it. We want to control it. And we want to say, but we can't. We have absolutely zero control.
No, I'm not trying to navigate the process. I'm just trying to. The only thing I'm trying to do is, and I'm not even trying to do it, but I'm just wishing that they would bring her the hell back so we could get started. I know I can't control that, but also when I picture Rob and Lindsay in the courtroom and John Pryor on the other side arguing, the better arguer to me so far is clearly John Pryor.
That's all he's got, though. Just think about that. That's all he's got. Technicalities. It's not
all bluster.
all it's true. It's technicalities. That's how they're gonna. If they did walk, that is gonna be the only way, because everything else is nailed against them. Think
Well,
about
yeah. And they're not going to walk. They're not
exactly.
going to
I'm just saying. That'd be the only way. Technicalities. Wait on somebody to f something up.
More people need to be prosecuted.
Yes.
Answer me this. John Pryor wanted the names instead of the numbers of the jurors of the grand jury. So he get the names of them. What if he gets with Chad and says, do you recognize any of these names?
Well,
Problem.
again, it's talking about such a small area.
I mean,
It's in there, KJ. There's nothing. I mean, that particular area is not 94% LDS, if I remember correctly.
I'm talking about if they see some grand jury member on there that might have answered a question that they didn't know Chad Daybell, and Chad could prove that he did know him. Then this is all a bunch of damn shit salad that we're going to have to damn pour some kind of dressing on and eat it.
And then marinate. Mm-mm.
And John Pryor knows this. And this whole ordeal of Lori coming back, let's get this show on the road. Hell, Chad is still under a waiver of speedy trial. And we don't know what Lori would do when she comes back. And you didn't hear one word out of Archibald's mouth, did you?
No.
maybe he can't. Maybe he's mute. He's a mute. Like, I think they're really rushed because they're gonna play. All they really have on Lori is like, oh, this is a mental illness. If she has a diagnosis, and they're gonna bring in God knows how many doctors to decide what it is, and they'll probably all disagree. And I think because Chad clearly hasn't been found incompetent, like Pryor is trying to separate Resch because of that. Because if either of them, out of the two, it's gonna be her that they're going to have sympathy for. if there is any, I'm not saying there is or there should or
Right. Just what if?
yeah. If because they've talked so much about her being incompetent and people have talked about diagnoses that
And all the
they
crap.
don't even know because they're not privy to the HIPAA information and
Nobody.
Right. And I don't have the answer to all these what if questions because
No, I
it's
don't.
just like Sanwillow says right there. You know,
Exactly.
I would
They should
think
be able to
so,
say that.
Sanwillow.
I mean, then you have a finger off of that saying or thinking, well, does that mean that John can still show up to Chad and I'm not a lawyer. I don't know the answer to all these what if questions. And if somebody does, please teach me, inform me.
Any evidence that John Pryor has, he's got to show his client.
Yeah. It just seems like the jurors, their rights are being infringed. You know.
Well, exactly. I mean, what about their rights, KJ?
Yeah, well, what about this? Take this, stick this
They're
in your
just
pipe.
supposed to get thrown
The
under
big
the bus.
Stick this in your pipe and smoke it. Did the grand jury indict them before or after Lori got put in the mental hospital?
Oh.
Somebody answer.
Damn near the same day for the murder charges. Damn near the same day.
Now
Isn't it all before?
let's get precise here. Did they get indictments before Lori was sent to the mental health facility?
Yeah.
Yeah.
They got
Technically, she did. They did.
okay.
It was JJ's birthday.
525, if I remember correctly.
Okay, so if now we're just talking hypothetical. That,
Thank you, Fresh Face. Sorry. Okay.
well, anyway, let's just for sake of argument here, that somehow John Pryor's able to prove some kind of misconduct of a juror or something to that effect, or something was impartial, and they had to reseat another grand jury. What would be the difference in a new one this time than the one that was held last time? All of the grand jury members would know that Lori Daybell was in a secure mental health facility this time when it was in before she was sitting in a jail cell. Optics.
I don't know. That's another what if question that I don't know.
Yeah. Just think about it. You know, these are things that we just have to kind of reflect upon. Yeah.
I want
I don't mean to be. I hope I'm not. It's not mean. I don't
You
mean.
are mean.
I'm more aggravated at myself because I should have looked at
There you go.
all of this stuff that's been being brought up, and I didn't realize that it was an issue until an hour ago.
Again, we're not attorneys, so we don't know that. I don't know to look this stuff up. We're learning as we go.
No, so please don't take me as being short with you.
Oh no.
I don't mean that at all.
I want to see her be tried in Arizona so fucking bad. I want to see her sentenced for Charles. Like,
Yeah.
I mean, it's just.
Lisa Bible here says, I was on a grand jury. We were not given names nor religion of people, only the charges. We decided if the case should go to trial. Bada bing.
Except if they're in Fremont County, if they know.
And it's a whole list he has to give to John Pryor?
Of
Or
their
just-
names.
Well, what's the point?
That's what I don't understand.
I would raise
But
hell.
the states, Lindsay did say we have their names, and if we have their names, they should be able to have the names too. That's what she's saying. And so, what would you do with those names? How would that help John Pryor in any way? We all have imaginations.
Yeah.
Why did John Pryor wait
tactic?
to ask for the names
Hadn't
until
even,
today? Why hasn't he been hyper? asking for that for months.
Well, it's the root of everything. Without the indictment, his client's charges gets dismissed. He's gonna
Right.
he is gonna attack that indictment. Just
But he could have been
before there
requested.
was an indictment, who was he attacking? Rob Wood, trying to get Rob Wood knocked off the case. But when this indictment came down, he couldn't attack the preliminary hearing of his client. There was nothing he could, no motion for anything to say this was not the right preliminary hearing or anything like that. And what I don't understand is the state had two ways they could go about this. They could have done a preliminary hearing, or they could have done a grand jury. And I understand why they did the grand jury, because they were going to be talking about both co-defendants. But Lori was already off somewhere. She couldn't have a preliminary hearing. She's in a stay. Y'all remember how Judge Edens was like, okay, in 14 days, you're going to have a preliminary hearing. When she came back, where Kay and Larry was sitting in the front row, she never did get to a preliminary hearing. And then this also has to do with who's going to be at the preliminary hearing, the witnesses. And you had subpoenas to Melanie P. You had Zulema and them there. The state had to lock these people in. And if you notice, John Pryor didn't say anything about the witnesses, that he had a problem with the witnesses. He was focusing in on impartial grand jury members and how he wanted their names.
Right.
If you had to sum it all up, and a lot of it was a bunch of juba jabba juba, you see that John Pryor, what he was doing, he wants this indictment thrown out, i.e., if the indictment's thrown out,
Oh yeah.
that dismisses the charges, because the
That was-
indictment are the charges.
that
But
was the whole reason for today. I mean, but what my question is, why hasn't he asked for the jurors' info until today?
because he had his thumb so far up his ass about thinking he could get the cases severed in the first place, and then when that didn't show up, this was his next thing to do. Because you said it yourself, Big E. He told them in the last one he wasn't going to follow up on doing all that to Rachel Smith, and
Right.
but then again today it was brought up about prosecutorial misconduct. So he's either changing his mind. I mean, I don't know why they're bringing it up if he's not going to do anything.
But did you hear either prosecutor's name specifically mentioned today?
No, but would it matter?
Well, yeah, it absolutely would, since he's had it written in the motions. He would have to argue why he was talking about Rachel Smith's how, I forget how he worded it, how many times she had let me find it real quick on my phone.
It's something about how much experience she had and where'd she been and all that.
Here's what he didn't argue today. For disclosure of homicide and death penalty cases, Rachel Smith has served as counsel or worked on pro hoc vice or consulting capacity. Never brought up. To disqualify the out-of-state prosecuting attorney, set aside the indictment and strike the death penalty. He did mention to set the indictment aside, but he didn't talk about disqualifying Rachel, and he didn't talk about striking the death penalty, which was listed in his motions. Hang on, there's several more that he had originally listed.
I mean, it could be that Chad told him something, and then he was like, "Oh shit, bye, Kay."
Okay, there was something else. Okay, so out of all those, to disqualify special prosecutor, set aside the indictment, strike death penalty, which I already said. And then there's a specific one to disqualify prosecuting attorney. He didn't argue, but this main one that he argued was to dismiss the indictment due to failure to seat an impartial grand jury. That's all we really heard. That's all we heard about.
And you
Okay.
noticed that Rob Wood wasn't there.
Was Rob there in the beginning, or was I
I
seeing
thought he
shit?
was there in the beginning. I
I
mean,
did too.
ultimately, Crescio, how do you feel? Because you said something really, I think, insightful earlier about you don't have control over it. And I know, like, you and your mom, your dad, you guys have talked about like the fact that they're not going anywhere, and we just knowing that you don't have that control, and then all of us were like, but we want that control. But how do you feel about the prosecuting team and their competence and the whole situation, like after watching this? Like, what are your thoughts as a family member?
Might help if I turn my mic on. Oh my goodness. My gut feeling has always told me that it is okay. It's like not even the prosecutors. It's in God's hands. I that's where my faith lies. I don't know. And I know that's not logical. I know that's spiritual
I think
based,
it's very
but
logical.
it's how I feel. And I trust my gut instinct. And I used to deny it, mute it, not listen to it, ignore it. And oh my God, 35 years of my life were pretty shitty, And then, I don't know. There is nothing we can do about it. However, I do like to talk about it. I do like to learn because I don't want to be, I want to be educated on it. I want to know what's going on. Is this normal? What can we do? I do like discussing it. It does get a little frustrating.
Yeah.
Well, and the thing you have to keep in mind too, and I put it in chat while the hearing was going on. If you would have told me that Rob Wood, Lindsey Blake, and Rachel Smith would have put a bad grand jury indictment together against somebody and nobody got indicted, I would have told you that I'd have bet everything I own and cut both my arms and legs off, saying that person was plumb full of shit. But by golly, they did. They put a bad indictment together. Nobody got indicted.
Yeah.
Yeah, I can't believe I've talked to you guys privately about it. I can't
Mm.
believe
You can indict a ham sandwich for not having cheese for the grand jury.
Hey, Gene Panek, you say John Pryor's keeps beating a dead horse about the grand jury indictment. Why can't he get that info? Well, he's got the full transcript of every word that has been said in the grand jury.
I can't.
So what he's wanting to do is he's wanting to, well, I'll just say it. He wants to shit all over this grand jury indictment, and he wants. I only thing I can think is he thinks he can get this case against Chad dismissed. Throw in a little bit of prosecutorial misconduct again.
Yeah.
He wants the names of these people on the grand jury. Because whenever he got the transcript of every word that was said, they said like juror 2 or juror 8. And John Pryor wants to know their names. And because the state does know their names, it is only right judicially that John Pryor receive those. And even Lindsey Blake says, we don't have a problem with that. We'll get you that. My question is why would he want to know their names? You know, that to me, there's so many options there for what John Pryor to investigate these people or try to find out if there's any any kind of connection with Chad or Lori or anyone like that.
Yeah.
Gossip. It's a small town,
Mm-hmm.
It could be
small county. People are
Could be.
gossiping.
if he makes a connect, and I'm just throwing darts at the wall, but if he sees something he doesn't like, he could plan on be calling that person as a witness during the trial. I mean, who knows?
I'm not sure about that. Those grand jury proceedings are supposed to be private. Yes,
Why is he getting it?
he gets their names, but he himself is under legal obligation not to share that with anybody.
Right.
Right. Yeah, true.
So you got in April, you've got them, they're going to supplement this today, whatever they talked about, and they're going to expound on what it is they're wanting to do on that. And,
Yeah.
Archibald was there today. I'd like to
Mhm.
know what Lori thinks about all of it.
Right.
Wouldn't that be interesting?
And Laura Hoare. Hope you're listening to this channel. You're welcome to come to Difficult Research anytime. Come on down.
Yes, and Semi and Mummy, I'd like to have a word with you.
Right. Yeah.
I'd like to have a word with Sulam. I'd like to have a word with all of you.
Yeah, we'll get Mom to make them some potato salad. So y'all want to hear something kind of funny, I guess? I don't know. I thought it was funny. So yesterday, whenever we were on the live stream with Scott Reich, right? So, I mean, I was just talking in chat to somebody, and I just want y'all to hear what he did. Scott did actually answer the question, or, he read a comment, but it wasn't the one I wanted him to read. It was to somebody else. But anyways, here it is. I'm going to play it.
Okay. Prosecution has to prove it beyond a reasonable doubt. Defense has to raise a reasonable doubt. I told Mom Larry we need to drive our buses up to the trial so we can get the buses and run them all over. Well, let's not do any harm to anybody.
It was funny because he got and he just like his shoulders dropped. And
Who said that?
Is that what you said, Chris?
Who said that?
That was Scott Reich reading my answer to somebody. I was talking to somebody in his chat, and he wrote it, and I was like, "No, not that one! God dang it!"
Hey, while I'm thinking about it, in the Lake Charles area down there, do y'all have RV places around there?
We sure do. What is the feedback? I'm getting a lot of.
I want to go to an RV park down there that's like near the water or something, somewhere really pretty. Do you know of a place?
Yes, I do.
Could you text it to me?
I sure can.
Because I'm serious. It's next month. You're our first stop.
All right.
When's
I'm
it
so
my turn?
excited. Huh?
When is it my turn?
Am I going to drive an RV all the way up? How far is from Utah to Idaho?
Right there.
Okay.
I'm about 3.5 hours away.
When I get up there to Idaho, I'll swing. What is it? Up or down?
Down.
I told you. Remember that community wall post? I listed your name. You think I'm going to get away from meeting you and Michelle?
Right.
I hope not, because I will chase you down.
Right.
Well, get over here. I'm gonna take you to the temple.
I'm serious. I'll give you plenty of notice. I don't want to be a burden to nobody. I just want to come by and.
You're not. I can't wait.
I mean, it's. I think that all the people, this whole community, this what I consider a conglomerate.
It's beautiful.
I want them to see us all meeting face to face, and I'll have gifts and things of that sort, and we can do a live stream. on your channels or whatever you want to
Yeah,
do. And
KJ, there it's amazing because when we do all get to meet, it's a love that's tangible and you can see it, you can feel it, like that's how I connected to and have stayed connected to all the ups and downs in this, is through a damn TV.
yeah,
And
well, it's going to be pure love for me when I take a bite of Jason's cooking.
right.
I'm going to be like, Cresha, why do you have to outdo me? My husband never cooks.
Well,
I do all the cooking. Don't you know? I have to have it cooked a certain time of day. I was in the middle of your live stream cooking, and I apologize for that.
that was funny as hell.
And then when I muted it, I couldn't get it back unmuted to say something, so I just left. I don't know this stuff, but
Me
I
neither.
felt
I know.
awful about it. I said, this woman's got this incredible news to share. And here I am, but I couldn't stop myself. I'm an old country girl. And when I'm disciplined, I start my suppers, at a certain time.
Well, yeah, I remember those days. I miss them, and I can't wait to get back to them. And thank God I have Jason for that.
Oh, and they say men cook better than women.
Well, I don't want to, bite the hand that feeds me. So yeah, sure. My mom makes one hell of a gumbo, though.
But El Mom, I'll take you and the missus there, Michelle. I'll take y'all out to dinner. That way, y'all ain't got to worry about cooking for me.
Oh, she's an excellent cook.
She's Italian.
I'm okay in a crock pot. But we do have traditional. It's kind of funny. We do kind of have traditional gender roles. Like I'm the cook, the cleaner, the kid person, all of that. She does the car in the yard
and the jokes.
No, we will take you somewhere. I just have to think of where would be a cool place.
Yeah, I figured if I get down there, if we need to meet like in a public park or a public place where y'all feel safe and I feel safe, not that we should, but you know what I mean.
At first, but then you coming home with me, babe.
Well, when I met Candace and my friend Jenny for the first time, they came to my hotel over there in the Smokies.
Yeah,
and I was a little apprehensive about it.
As you should be. You should be.
But it really was fabulous. 2 really wonderful women, awesome women.
I love how they talk. They just, yes, ma'am, sure do. They really just flow off of each other. It's really cool to see. Yeah. I really appreciate them.
And there have been several people saying, well, KJ, if you're going to come through Virginia or if you're going to come through Alabama or Georgia, please let me know. I'm going to do it. I mean, out of my own expense and everything, I just feel like, what's the use? I can sit online. I can sit on YouTube. I can,
my butt hurts though. I'm ready to, I got to move.
Yeah. And,
my butt hurts from sitting.
I mean, I look at it as a big honor to be able to meet anybody that I've never met before. I love people and I love to just meet them.
Yeah. You're adventurous like that, it seems.
Yeah.
I want to be a little more like that. Happy birthday, Rhombohedral.
Happy birthday.
Thank you for spending it with us. And I mean, just everybody here. I feel like the victims, Tylee, Tammy, oh God, did them out of order. Tylee, JJ, Tammy, Charles, Joe, I feel like they all are up in heaven and they just handpicked every one of you guys and just put us together. And that's just why I call y'all God's army. There's no other way to really see it. It's really cool. And it is the silver lining in all this. And I can't imagine going through days like today or days like Friday, I think it was. I don't even know anymore. But I don't think I could get through it without this amazing, beautiful, smart, funny, loving, supportive, just group of people. It's amazing.
But sorry, I keep interrupting. You are an amazing person to get to know. Like you have so much strength and grace. I could never have the grace that you have. I'm far too bitchy. And the fact that you're willing to share your perspective and experience with us is such an experience. I mean, I've learned so much from you, and I just I'm really glad that you emailed me and I checked up on you, made sure you weren't some crazy, because you can never be too careful. That's why,
Right.
I mean, speaking from, I mean, I have had experience.
I'll
Yeah.
tell you what, I like Big E. Big E's got good head on his shoulders.
Yep.
He's tough. He's strong. He's intelligent.
My big brother.
He's down to earth.
Somebody lied to you about the intelligence part.
Well, I think you don't give yourself enough credit. All I'm saying is that you keep a level head about you, and I like that.
You stay on top of things. You're very, very persistent, and you're on top of things. And I had that in itself is awesome. But the fact that you personally have, from the beginning have reached out and given us trigger warnings and things like that, you're protective.
Right.
And that is very nice. That's very nice. That's about it's the only real level of support, or what am I, trust or safety.
Yeah.
Like a safety net, and it's, that is big, very big.
The fact that you were able to get information from Wayne County, that's impressive, dude. I don't know what the hell is wrong with Grand County, but Wayne County, I was like, nah, there's no way. You're a charmer.
Hey,
He said he was going to move to Utah, and I'd be like, oh my gosh, I would have a real life friend.
hey, I hate to change the subject real quick, but I have to ask El Mom this. I haven't seen anything more about that fella that was arrested for that college student girl, the Allen girl.
Maddie.
It's almost like it's just been swept under the rug. You don't.
Tell her your reason though.
Well, I think for me, once I saw that she did not want to be involved, she didn't want to be named, she wanted to move on, I couldn't cover it anymore, just because I thought, if she were my daughter and it was my family going through that, because she went through such a horrible ordeal, I can't do that to another mom. So I haven't been following it.
But what I'm saying is you don't see anything else about his adjudication at all.
And you won't unless you call.
County.
Oh, Lisa.
Utah is absolutely off the chain ridiculous at trying to get things.
Yeah, you can't get any information.
Oh my God.
It's not her that I mean, God bless her and everything. I'm just wondering what they're doing with him.
Right.
Well, even him, I mean, to even get a prisoner list, I think it can get one from the prison. Is he in Sevier County jail?
He was last time I checked.
Let me check something.
And that's kind of sad, because this was back when we was covering the case, but there was no media showed up for his hearing.
Well, I think sorry.
And that could have been a reason for that. There could have been a reason. Maybe the parents didn't want any more on it than there needed to be, and maybe they asked the media not to do it.
Yeah. From what I understand, I have a contact with one of the newspapers. That is what she said was that they wanted to respect that. It looks like they have a prisoner list. I'm looking it up right now. Let's see if that piece of shit is on here. There's a lot of people in that jail. Sevier County is not that big. Jeez. All drug charges, though, because it's a small town and there's no money.
Does anybody on here know whether they're going to be for sure at the trial, whether in Boise or Fremont?
I'm praying for Suzanne, Jean. I was going to tell you that. Definitely prayers going out to Suzanne Morphew. Justice, May 3rd is my birthday. So there you go. Tammy's is May 4th. We're going to get our birthday wish.
Officially right
I
now,
don't like ugly.
KJ,
Whoa.
if trial started tomorrow, it would be in Boise. But we still have the hearing coming up to allow the additional evidence on April 19th. To, I guess, for the state to
Well,
bring in the rest of
yeah,
it.
just getting past that, say, just for sake of argument, they have it at Boise or they have it in Fremont. Is any of y'all going to be there?
Oh, I will.
Oh, the trial?
I mean, actually in Boise or actually in Fremont?
Oh, hell yeah. Absolutely.
Thank you,
I am.
Ashley, so
Absolutely.
much.
I will do whatever Crusha wants me to, even if it means going to crowd.
Oh, I'm right. Me too. I hate crowds. Oh my
We'll both
god.
be like social anxiety.
I'll jump out of there every chance I get. But
I mean, I know that
stories.
the hotels and all that stuff are going to be filled up by that time and everything. Just
Oh yeah,
know this: I'm going to the nearest RV park.
I'll spend a night over there with a
You're
tent.
welcome to. If I mean, I've got air mattresses. I've got I've got 3 bedrooms there. Plus, by that time, it being in January, I have a fireplace.
Wow, we have some bonfires outside.
Yeah, I'm gonna have bonfires. I've got actually have a portable bonfire metal thing, that you put your bonfire in.
Yeah.
And if anybody wants to come and hang out, or if they need to stay a day or two,
I was thinking that we could do some kind of like, maybe that's what I was going to offer with the Patreon thing, is like not just Patreon. It will be for everybody also. I got to figure it out and just kind of bounce the ideas. But to report daily from family perspective,
Right.
like
Right.
from this perspective.
Bingo.
Because I mean, it's different. I don't know. This is weird. I've never done this before in my life, and none of us really have. We weren't prepared for this, but just as anybody else would do.
Yeah, as far as KJ and the Ray channel and everything,
Yeah.
The people on there are going to probably get sick of me because I'm going to be live streaming all the time about whatever I've heard, whatever I've seen.
You can do it through here, even just whatever, however you want. I was going to offer that to you, but
however you want, however it's done. I'm not tech savvy, but
it's
whatever. Easy. I would be more than willing to do that, and it's for the community. It's
right, exactly.
Right.
And also, we've got to figure out a way, if I do that, where I will not have absolutely nothing to do with anything on my channel with super chats or anything like that. But if it can be like put over onto your channel, or if it's just me telling people to go to your channel, whatever, hey,
we'll just do a little lanyard.
Yeah, and I'm also wanting to do that art auction as well. So
yeah, that'd be great.
So
that'd be great, KJ. You don't realize how much you give to the community.
Well, I want to do it because you can live your life and be nice to people all the time, but if you're not giving and giving for a good reason, then it's not about making me feel good. It's about doing the right thing.
I understand, and that's very, very, very genuine and just very kind. It really is. I was just talking about overall. You give.
Kathy, I believe you will help me, honey. Kathy's just a diamond in the rough.
Mm-hmm. Yes. Thank you, Kathy. I know.
Yes, he is.
Here's the thing, though, KJ, that I'm worried about, and that is the COVID factor about how many is going to be actually allowed into the courtroom.
Well, I've got to stand outside in an owl mask with a shirt saying "Chad, who killed everybody."
Oh, you don't have to mask in Idaho.
I'm going to. I'm bringing my owl mask.
I'm gonna do one with the big old lips.
But it's starting in the dead of winter.
And
And I want
I've never experienced an Idaho winter.
we're gonna get a big box of Poo Be Gone, that spray.
Can we start a petition now? I want them to wear masks that are see-through.
Poo.
I want to get that going now, like now.
We're gonna get some of that Poo Be Gone. You know, the spray stuff you spray in the toilet so it don't stink. So we'll have some for Lori.
Yep, and nothing can cover up that smell.
Yeah.
Thank you, Ashley Kane. Thank you for the super chats. I gotta get busy on my video though.
Hey, you could do that because
I've got to. Well, I have makeup on right now.
I got to promo it.
All of y'all remember, I have Ray Room chat tomorrow evening as usual.
Awesome. Thank you so much, KJ. Thank you, Eric.
I wish we would have gotten more out of today's, but the bottom line
We
is
will.
John Pryor's just shitting in one hand, hoping in the other.
All right.
Yeah, that's all I got.
I love you all.
Love you all.
I love y'all. Love always wins.
I have strong like feelings for you all.